All right, guys, so I'm here. I'm outside the federal courthouse. Basically, I've just attended the Durk hearing, and I've got a huge bunch of updates for you guys. So it's very, very interesting, everything that went down. I'll be honest with you, it wasn't the best day for Durk. It was definitely, you know, not as good as the last date. The last court date, he definitely was getting a whole bunch of big W's, and he was kind of, you know, finding himself really tying up the prosecution. This time, the prosecution kind of had a lot of W's on their side. So I'm gonna break this down into two different videos, but the two major rulings that were made today were about Durk's lyrics being used, and then also you know, the situation with this phone that was seized from him. And I'll be honest with you, in both of those instances, it wasn't a great result for Durk. It was kind of bad news for him on both fronts there. So basically, in this video, I'm gonna break down more on the lyrics side of things, and then I'm gonna kind of explain to you what happened when it comes to, you know, the phone evidence and how that went down, which really wasn't the best for Durk. I'll do that in a separate video because there's a lot to get through. I've got my notebook and everything with me. I'm just going to try and break everything down. So basically, like, Durk came into court smiling once again. He kind of dapped up his lawyers. He hugged Brian Steele. He was in really good spirits. I feel like every time Durk pops out at court, he puts on like a very positive display. He puts on a positive show, like a real show of force when it comes to kind of like, you know, the persona that he's putting on in the courtroom. He's coming across very positive, very happy, laughing, cracking jokes. He cracked jokes with his female lawyer. He was hugging Brian Steele. They were all laughing hard and smiling. Now, Durk's co-defendants looked a lot more serious, if you ask me. They all kind of spoke with their respective lawyers in kind of sort of, I don't want to say hushed tones, but, you know, definitely kind of like looking quite serious. It was like Durk was kind of cracking jokes and not messing around, but like looking very, very happy. Everyone else behind him looked a lot more serious. Durk was kind of looking around the room. He was smiling at different people in the gallery, nodding to different people, basically kind of, you know, putting on this very positive display. Now, he did that last time and he ended up taking the W. This time, it wasn't as good. And there were some wins for Durk, but it was, I would say that it was mostly L's in this hearing. People want to say that, you know, you're Team Durk or, oh, stay on that side. Look, I'm on the side of truth. I came to the hearing a few weeks ago. He had a really, really good day. The prosecution were definitely in bad shape. This time it was a different story. Prosecution were taking the W's, and Durk's teams, Durk's motions that he were making weren't really working out too good. So basically, what ended up happening from there is the judge was kind of breaking it down, basically talking about the schedule. Now, I heard originally the trial was set to start on August the 20th. I heard people talking beforehand in the hallways and things about maybe the trial might get delayed a little bit, might not start till the 25th. This was supposed to be like a big one-off hearing, but it was then being reported that, you know, it would basically be like potentially extended to another hearing. There was so much to get through, and they kind of got through everything today, but it sounded like there could be more back and forth before jury selection starts, and they were hoping to give an estimate of the trial. They mentioned it a few times that like the trial would be like, you know, potentially 2 to 3 weeks is what they were aiming for, but as I'll tell you a little bit later, there was definitely some stuff that came up that made it seem like that might not be the case. But what I'm going to do is I'm going to hand my camera over to my trusty helper right now, who is going to help me with this. I'm gonna stand like over here off to an angle. Hopefully this works. Hopefully I'm looking good. Am I all in focus and everything looking good? All right, sweet. So basically, what was interesting is they kind of went back and forth about a whole bunch of evidence that came up. Now, what was very interesting was that Durk's defense said a few things that were kind of like getting at some of the stuff that was going on, that they weren't happy with it, but it didn't really necessarily go their way. They said that some of the conspirators, the co-conspirators in the case, are being used as de facto experts. There was talk about some of the different cooperating witnesses that were involved in the case and how they were going to be used, and it sounded like Durk and them weren't too happy with how some of those, you know, statements were actually going to be used against him. I don't really think that that was acknowledged in like a big way, as far as I don't think the judge or the prosecution really cared about what they were trying to say about, you know, the validity of the co-conspirators. There was some stuff that came up later on where they were trying to say that, you know, because the co-conspirators, they were offered proffer agreements, they'll say whatever, they're not going to argue with the government if what they're saying doesn't add up. It doesn't really matter, because at the end of the day, it seemed like what the judge was adamant at throughout, whether it was the lyrics, whether it was the phone evidence, whether it was the different experts on either side, he is a judge that wants to let both sides and all of their witnesses, anybody that they want to bring forward, have their say, have their day in court, and basically have the opportunity to communicate, and it's up to the jury to decide. The judge really wasn't going for either side, trying to block evidence, block lyrics, block witnesses. The judge was really on some stuff where he was like, I want to let everything get laid out in front of the jury and then the jury to decide. So they said that, look, we're a week from trial. They went back and forth. They basically said, look, if the defense is calling a non-expert witness, they need to be identified right now, and we need to know how long they speak in hours. The judge was basically like, look, we don't want to be going for months and months and months on this. We need to respect the jury's time, we need to respect my time, we need to respect each other's time, and that we don't want to be spending months and months trying this case. So basically the first motion, the judge was really not taking any nonsense. The first motion, the judge basically said, I'm not going to impose a gag order. There was this attempt from the prosecution to say that they wanted Brian Steele and Drew Findling to stop making statements in the media, stop trying to taint the jury pool, as they were saying, to, you know, muddy the waters and turn everybody against the government and make it seem like Durk is being unfairly persecuted. The judge basically said that, look, he's not going for the gag order. He said that he ruled on the Derrick Rose case a couple of years ago, and that basically that was a whole different story. So using that as an example is not going to work. That was much more vicious. Said that it was much more, you know, unambiguous attempts to try and influence the jury and like put some sway into what was going on out there. The judge says, look, he doesn't see the need for lawyers going on the record with the press. He said, I'm not going to put a gag order on you, but I don't see the need for you guys to go out there, be talking to the press, talking to the media. Drew Findling doing DJ Vlad interviews, shout out to DJ Vlad, but you know, that's been brought up in paperwork a couple of times, and it sounded like the judge didn't really appreciate all the attempts for the defense counsel to basically go out there and try and spin the narrative in the media. And the judge was very hard. He said, look, I'm not going to allow the gag order, but okay, I am going to be strict. The judge said lawyers, some of the lawyers on the bench, I think he's talking about Drew Findling, and you know, Brian Steele, obviously he's infamous for dealing with the YSL RICO case in Georgia. Drew Findling's done a lot of work for Youngboy and Baton Rouge, and he's got ties down there in the South. The judge basically made it clear that some of these lawyers, they're not members of the California Bar Association, or that they're not necessarily California-based lawyers, and that if he wants, he could turn around and say, look, only Miss O'Connor, who's actually representing California in this case, could be the only person who can actually talk and prosecute this case as far as actually being in court, if he wants. And the judge says that if he feels like it, he can admonish and refer bad acting lawyers to the California bar. If he feels like these lawyers that have come from out of state and are then talking to the media, taking liberties with the truth, are interfering with the situation, making things worse, then basically said that he can like admonish them, and he can sort of push them in a direction where they're going to be in trouble and they're going to be less able to represent their client. Now, where's my Gatorade? I got my Gatorade right here. It's all good. So that was really interesting. The judge was like very firm but fair. So the prosecution, you know, they didn't get their gag order that they had hoped for. So that's sort of a W for Durk's crew. But then the judge warned them pretty firmly. He said, look, if you guys are out there in the media saying stuff that's compromising the case and going beyond what you're allowed to do, I will admonish you and I'll make it so that you guys can't represent. So that was very interesting. He basically urged them directly. He said, I urge you, don't speak to the press. And any statements that you do make with the press or publicly, you should make sure that it's appropriate with California press rules as far as what's being reported in the courts if you're involved in the case. So the judge denied motion 1 without prejudice. Now, the defense said that, you know, they felt like the government was putting information out with gratuitous public filings. So even though the gag order wasn't offered, it seemed like the defense, they were trying to defend themselves a little bit and say, oh, you know, we weren't making statements to the media that were going to cause any problems. And I'll be honest with you, the judge wasn't feeling it. I feel like really Durk's team should have taken the W and shut up. They kind of wanted to clap back and defend themselves a little bit after getting admonished and warned, and that didn't really go in their favor. They said, oh, well, the government's putting out these gratuitous press, public filings that are being used in the press to kind of like, you know, basically saying that the public filings that the state were making were kind of damaging Durk's character and potentially tainting the jury. And the prosecution said, we haven't filed anything gratuitous. We filed the allegations as they are. We've put them out in the public. These courtroom proceedings, they're in the public interest. And the judge basically just outright denied the defense's request and basically made it very clear, look, the court and justice and trial should be in public. It's in the public interest. There should be no restrictions on lawyers, whether it's prosecution or the defense, to make filings, to make their cases, to make their claims, and then kind of, you know, make denials to those claims. That's completely on lawyers. That's their job to make these filings. So the idea that, you know, the defense were trying to say, oh, well, they're making these gratuitous public filings. No, they're doing what they're supposed to do. They're doing their job and filing the information and the evidence and warning the public about what they think is going on and making the accusation against Durk. And it's up to the jury to decide what they think of that. So that's not the same as Drew Findling sitting down with DJ Vlad and, you know, doing an interview and talking about how ridiculous these charges are, or like how Brian Steele in the YSL case, he did a whole lot of talking about how, you know, they were unfairly tarnishing Young Thug through his lyrics and they were discriminating against black art, when in reality, what was really going on was that Young Thug had made incriminating statements and real crimes had gone on that appeared to line up to those lyrics. Now, he took a plea in the end. He admitted to being involved in the gangs, but anyway, that's a whole other story. So there's no gag order on either side, and they basically said it's rare for things to be filed under seal. So the idea that the defense want to say that, you know, just by filing motions and filing paperwork and filing indictments, that's somehow like gratuitously putting negative stuff on Durk's name was just like not accurate. So then we moved on to motion 2, and basically the judge said this was kind of moot. Defense didn't really have a problem with this. The judge really explained that this was about 2 things, and this was the motion that was all about basically both sides went tit for tat saying that their expert witnesses should be excluded. The government want to bring a gang witness who is apparently a Chicago gang expert that can testify to the activity of the Black Disciples, which Durk allegedly is a member, the Gangster Disciples, their ops. And really what we saw in the filings was that the government was going to kind of make a case that, you know, this LA murder that took place in 2022 had all the hallmarks of a Chicago gang assassination. It was very public, it was very brutal, allegedly switches might have been used. And then in opposition to that, the defense were planning to basically bring forward these gang experts, these music experts that were going to testify to the opposite and more take like a very sensitive sociological approach, suggesting that, hey, well, actually, really what's going on is that, you know, these guys, they're just making rap beefs, they're making money, they're doing kind of WWE style gangster rap, which isn't actually necessarily correlating to real crimes. Now, I think there is some validity on both sides. It seemed like they were going tit for tat, where basically, like, you know, they wanted, like, the defense wanted to exclude the prosecution's gang witness, the prosecution wanted to exclude the defense's gang witness, and they're basically going to give opposite sides. Now, the judge basically said some really interesting stuff on this. They said that they feel like the government is over-relying the judge was concerned about 2 things. One, that the government might have been over-relying on informants and rap lyrics, and they said if the defendants disagree with that, that's the whole point of the trial. That's not an opportunity for you to get evidence and expert witnesses thrown out. That's an opportunity for you to make a case against what the government is saying and bring that in front of a jury and have the jury decide. And then they also said that there was some concern about misconstruing things that were in the superseding indictment, and the judge basically made it very, very clear. It said that so it's like, basically, Durk's concerns about things in the previous indictments being wrong are irrelevant. He basically said, I don't want to hear no more talk about the old indictment, that there were mistakes in it. That's not the indictment we're going from anymore. The old indictment has no bearing on anything. The superseding indictment, it supersedes the original indictment. It's a new indictment, it's new information, it's on top of, it is superior to, if there was a mistake, if there were typos, if there were the wrong links in the first indictment, it doesn't matter anymore because we're not dealing with that indictment anymore. Made that very, very clear, and the judge made it very, very clear. And again, this was kind of a little bit of an L for Durk. And look, a lot of the Durk supporters have been clutching at this one straw, saying, oh, well, in the first indictment, they filed a version of the wonderful Wayne and Jackie Boy song that he did with Babyface Ray, where he talks about green light, got location, go, look at your son on the news, he's screaming, no, no, and superimposing that with a clip of Quando at the scene screaming, no. The prosecutors accidentally used the wrong link. They used a fan-made link rather than the actual song in the first indictment. That was a mistake, but we're now on a superseding indictment, and a lot of the fans, and it seems like even Durk's team, they keep on bringing up this same thing. Well, they used the wrong link in the old indictment. Well, the old indictment's gone. It's no longer. It doesn't matter. You can't fight against indictment 1 when we're on indictment 4, and those are not to be dealt with, okay? So the judge seemed like he was actually getting frustrated with them constantly bringing up the old indictment. They said that, look, the defense is not permitted to reference old indictments with mistakes. The defense said, you know, there shouldn't be a blanket ban on evidence. You can't just, you know, rely on what the government says. And the judge says, look, you can attack witnesses, witness statements, experts, the evidence, but you can't attack the government themselves. You can't say, well, because they made a mistake in one indictment right at the start, you can't believe anything they say. When we're not, the jury isn't to be seeing that first indictment. It's irrelevant. And so the defense then went on like a very weird tangent that didn't make any sense. And they basically said, oh, well, can we give you an example? They said, oh, if we show Durk holding a bunch of money, you know, the government are going to say that it's a crime, but we want to let the jury know that, you know, he's a rich rapper, he's a multi-billionaire, he's doing songs with Drake. And the judge said, look, you can attack what a witness says. If a witness says he got his money from crime, you can attack that and say that he's making money with Drake and show some proof. They said, but you can't attack that the government made mistakes or the government said the money was from the wrong source in the first indictment, which was never alleged, by the way. So it was really like, this was just going off on a tangent. So they basically, the judge explained, the trial will be witness driven. If a witness lays foundation for money being gained from a crime, then they can respond saying, no, Durk actually makes legal money, makes songs with Drake. Drake's name was brought up a few times. It's clearly, the judge clearly knew who Drake was. They didn't need to explain who Drake was at any point. But they said you can't tie government mistakes up in like old government mistakes from an old indictment up with what's going on now with this new evidence in court. And they said you can't tie that up with jury nullification. It doesn't matter. It's not relevant. We're not expecting the jury to have read a first indictment that's been superseded, that's not relevant anymore. So the prosecution basically went on to say, look, all of this is nonsense. We're not intending to introduce any evidence related to him having dirty money from the streets. They also said that they thought that the defense had told them that they were planning to introduce no evidence of his endorsement, his collabs, or his business. This isn't a case about money. It's a case about a murder. And they said no one's disputing that Durk is successful as a rapper and he's doing songs with Drake. No one's disputing that. They said we're talking about money that's been given to participating witnesses, and basically like they didn't say this, but where I read between the lines is what I thought they were saying is that like it's not there's no reference that the money is dirty. The only thing that's dirty is that like Durk's done songs with Drake made millions of dollars and then put that money in the streets to pay hitmen, right? That's really, they didn't say that, but that's what I inferred from it. So the judge basically said, look, if you think the money came from illegal activity, you can just ask. And the government said, well, that's not what we're trying to say, so it doesn't matter. So after that, the judge basically went on and said, look, we don't often have murder trials here. And this is when we got to motion 3. So this was kind of the back and forth about the expert witnesses. So I'm going to tell you about this, then I'm going to get to the lyrics, and I'm going to wrap it up, and I'm going to talk to you about some other stuff in a different video. But for motion 3, both sides were trying to exclude each other's expert witnesses. Now the judge said, look, we don't often do murder trials in this court, but I do a lot of civil rights cases where like the LAPD have shot and killed people, and you know, he basically said people often try and exclude and disqualify both sides. They didn't say this, but I would assume they're talking about, you know, evidence that has something to do with civil rights, maybe certain persecuted groups being treated differently by the police, and any evidence of that expert witnesses to potentially talk about, you know, corruption, racial injustice in the LAPD. Obviously the Rodney King case comes to mind. And the judge basically said, look, my usual thing I do is I usually deny both motions, and I like to allow witnesses on both sides. Let's get everything out on the table and let the jury decide what they think. They said if it was a time thing, he said if we're really pressed for time and we're not going to get this case tried in a good amount of time, he said I could argue that, you know, we could limit the time on both sides. I could exclude both witnesses, but he wasn't trying to give like an unfair advantage to one side or the other. So I thought that was really interesting. It's getting kind of windy out here. It's also windy all of a sudden. I don't know if we should maybe go for a little wander, or if we should move around. But I swear it is mad windy all of a sudden. What I might even do is like go sit down or something. Sit down on some steps. Tell you what, let's go sit on the steps over there. I'm gonna pick up all my junk here, and we're gonna go sit on the steps because I don't want to get torn apart by the wind, and also you probably can't hear me. So let's walk and talk a little bit, all right? So I'll keep talking while we walk down here, and then I'm going to sit on the steps. Hopefully I can shield myself from the wind on these steps. But anyway, it was this kind of back and forth about, I know the wind's whooping the mic right now. I mean, look, we're downtown LA. We're kind of at the courthouse. You know, it was interesting. I just got told off. I tried to record this video prior, and I got told off for recording right outside the court, which I thought you were allowed to do. So it's very windy. That's the courthouse over there where the David trial was going on. So there's been a lot of really interesting cases going on, like on this little set of blocks. That's like a block and a half away, I guess. But like, let's go and find a little spot down here. Maybe this little hedge over here is going to have like a better a bit of wind blockery or something, or I don't know, I might have to duck down behind one of these buildings. But basically, like when it came to that back and forth, the judge made it very clear he wants to leave it up to the jury. He wants to basically like allow both, if there's time, allow both experts to kind of talk about what's going on freely, openly, let the jury decide what's going on with that, give all of the testimony, and basically they said it's up to the lawyers to decide how many experts are going to be kind of allowed to talk in this situation. So from there, there was kind of another motion from Didi. They basically said like, what did it say? The government was allowed to close by saying if they, that didn't make sense. So Didi's lawyer basically brought up like a separate motion. And let me just get my ideas. So they're basically saying that, yeah, so Dee Dee's lawyer basically brought up something that was quite interesting. So I'm not getting too much wind right here. This is good. This is good. This is the spot. So there's all sorts going on. We're really outside right now, man. We're really outside reporting. So don't lose my page. This is like no wind zone. So like from there, what we ended up hearing was that basically a motion was filed because they felt like the government, Dee Dee's lawyer basically said that the government violated notice obligations. They were supposed to submit like an expert report related to, I believe, cell phone extractions 30 days before the trial. They said it wasn't submitted in time, it should be excluded. And the judge basically said they did actually submit it. I don't know why you're saying that. And sometimes things change. Sometimes they basically said it was a cell phone extraction, but the expert that was supposed to present that to the court, I believe, had changed. And the judge basically said, look, sometimes things change. They noticed you have this evidence. I'm getting winded again. Do you think if we sat on the... Am I really going to just sit on the floor? I might just sit on the floor. I'm going to sit on the floor. Do you mind sitting on the floor? We're really out here sitting on these downtown grounds right now. Just trying to get away from the wind. So, the judge basically said, like, look, you can... They've notified you that this evidence is going to be brought across. They've kind of like made it very clear if they change the person who is actually going to like explain this in the court, it doesn't really matter as long as they've actually like made a filing for the evidence itself to be broadcasted. And if the person presenting it switches over, it's not really a big deal. It's really not a big deal. Am I looking like mad blown out? Because I feel like the sun's come out since. I got the shutter speed down. Is it all good? Yeah. So anyway, the judge was like, look, they submitted it. Sometimes things change. They can swap out the experts. If the original expert isn't available, he's like, things happen, you know, people get busy, they die, they get sick. Like, if they need another expert, that's fine. They introduce the evidence. Now, Dee Dee's lawyer said this is untrue and things kind of got heated. And I'll be honest with you, this was an example of where someone kind of got heated with the judge, and I don't think it worked in their favor. I think he made himself look a little bit flustered, and I don't think the judge appreciated the intense tone that he was coming at him with. So after that, the judge basically said, well, what information does the defense have to cross-examine this witness? Like, you really need to focus on the information that you're going to bring against this witness rather than trying to argue this idea that, you know, they didn't file in time, they changed the witness, it's the name's changed, but the underlying information is still the same. So they basically talked about, look, the prosecution gave their response and they basically made it very clear. They said, look, we have a 120-page presentation. We submitted this. We're going to have a different person present it. And Dee Dee's lawyer basically admitted, yeah, you know, they put across, I won't say the names, but they put across one person as a witness. They then swapped him with another person. And the prosecution said, yeah, it's a different person, but they're going to present the same report that you've already had. We produced the report all the way back in 2024, right after the arrest. We produced the whole report. You've had this for time. Just because a different person's going to present it, it doesn't really make a difference. And they also pointed out, like, I don't know if they were trying to infer that they'd been, at least Dee Dee's defense hadn't really been on the ball. But they said, we produced the report in 2024. You didn't ask a single question right up until the responses were due. And they basically said, look, we gave appropriate notice about this evidence. We gave articles explaining all of the data, and we're even preparing an even more detailed breakdown of each slide, just so you get all the context and understanding. Dee Dee's lawyer went off on this crazy rant, and low-key, I felt the way he was talking to the judge was low-key disrespectful, to be completely honest with you. He said, this PowerPoint isn't a report, there's not enough explanation, the court says that experts should fight it out on what's reliable, but we disagree. A PowerPoint isn't a report on the opinions of what's in there. The government thinks the onus is on the defense, but they're not following the rules to call it out, and the court admitting this change of person violates Rule 13. The judge basically was like, look, the government has to file all materials. They did. And then, like, Dee Dee's lawyer just kept off going on. He brought the topic to another area of conversation that I thought was low-key, like a little bit weird. Started talking about, like, this whole thing with the switch, and they said, oh, this special agent is going to testify that a machine gun was used, it's not relevant, it's tainting the jury. And then basically, like, the government, the judge was like, well, the government thinks it's relevant, like, to the charges. I mean, you've basically got, you know, a machine gun being used. That is basically increasing, like, the viciousness of the crime. It's increasing the likelihood that the person being attacked is going to be dead. It is pretty much, like, completely fair game. Dee Dee's lawyer was like, the dangerous weapon doesn't have to be a machine gun. The use of a switch to make a pistol a machine gun, it doesn't matter. All these details aren't important. And the prosecution said, well, look, there's multiple things the government must prove. One of the things is that the conduct intended to cause emotional distress or, you know, or extra effort to basically make this a murder. And they said that's related to the machine gun. And the judge says, well, why do we need to have explained the use of a machine gun by this particular person? And the prosecution said, well, this is going to prove the callousness of the murder, the intent to kill, the reasonable fear of death by the use of a switch or that turned a pistol into a machine gun. This proves a whole bunch of things that are important. And the judge says, well, okay, submit the whole report under seal, I'll look it over. And then Dee Dee's lawyer kind of kept clapping back, saying, oh, the expert shouldn't be testifying on what any other expert did to tamper with the evidence. And the judge basically said, why would he be able to talk about anyone else's dealing with the evidence? The way people have dealt with the evidence isn't a conversation here. It's just not relevant. Basically, just kept explaining like these aren't things that are relevant, and that we're kind of going off course here. And the judge said, look, is this in violation of the confrontation clause? We need to include like all of the people giving their opinion. If you want to argue against it with the jury, you can. And the prosecution said, look, we'll make a filing and we'll present to you guys extra case law on why that this should be completely allowed. And the judge basically said, all right, well, I'll go over this, and then we'll move on to the next thing. But if Dee Dee's lawyer, if the prosecution want to make a case for, you know, this machine gun clause and this extra information and this expert testimony being brought, they can. But this idea of like, oh, they're switching the person out last minute, it breaks the law, the judge wasn't going for it. So let me see, I don't leave my drink up there. Let me see if the wind's still going. I'm really out here in the trenches right now, laying on the floor. I'm feeling some wind. Maybe it's not too bad, I don't know. I'll bring headphones next time and we can listen. Let's sit on the ground again. Let's get comfy and sit on the ground. I'll find us a way better place to film for the next segment. But anyway, okay. This is the most important part of this that we're getting to now, which is we're going to get to the lyrics soon. So we kind of like went back and forth about a couple of things that weren't that interesting before we got to the lyrics. They basically kind of were just like saying that, look, the defense is allowed to use the same evidence as the government. They can use all of the evidence that the government have claimed in their investigation to poke holes in what the government's narrative is. From there, they basically said that, you know, we want to use everything that's on the phone, all of the phone extractions, we want to use that too. And, you know, obviously the government said, well, we presented to you everything that was on the phone. So the judge said, look, I would have told them to produce all their evidence if you asked for it. Prosecution said they had a deadline, and they only submitted a handful of documents. So what it sounded like was that the prosecution were basically saying you had a deadline to submit everything that you were going to use. You didn't really submit that much, and now you're acting like you want to submit more stuff or you want more of our stuff. And the judge kind of slapped them down a little bit here, because basically, like, the defense was saying, well, look, we can use all of the same evidence that the government are going to use. And the government were kind of like, well, okay, what extra evidence are you guys going to submit? It sounded a little bit like the government was saying, look, we got all this evidence on you. You guys are going to have to argue against this. What are you actually going to bring? And they said, well, we've got very little extra evidence that we're going to bring, other than these expert witnesses that are going to say, you know, everything's all about the sociology behind the gang music and these rap beefs are fake. The prosecution said they had a deadline. They didn't submit many documents, and the judge said, well, that's all they're allowed. The deadline's gone now, okay? Now, basically, Dee Dee's lawyer kind of was still going back and forth with the judge at this point about this new motion, and they basically said, well, we're not obliged to point to exactly what evidence is in their own possession. Basically saying that, like, if there are holes and inconsistencies in the government's evidence, like, for example, the phone extraction, they're not obliged to point out and say, oh, you missed something here that actually is going to make your prosecution argument against us look really bad. They're not obliged to. If all of the phone records are already out on the table and the defense are going to say, well, this part actually absolves us, they're not obliged to tell them that. All the evidence is on the table. The evidence is on the table. We're going to talk about it in front of a jury and decide then. So that was a really interesting back and forth. And then the judge made it very clear that it was like, okay, well, look, if there's evidence the government didn't produce as well, they're only going to be limited to the handful of evidence that was produced. It's too late to submit new evidence at this stage. And they basically said, look, it's 1 week to trial. They're saying that the government have made a lot of broad statements. The judge basically said, look, I need to know what are all the witnesses that we're going to be having here. I need to check that the jurors don't know the witnesses, and then I need to get an idea of how long the trial is going to be. So I won't ask these specific names at this stage. I'll just ask, do you want more witnesses than the experts that are currently put up here? Do you want more witnesses than the 4 experts and the defendants that are currently in here? Now, Durk's lawyer said yes. And the judge said, well, okay, any extra witnesses that you want to disclose, you have to tell me ASAP. That was just Durk's lawyer, so Brian Steele, Drew Findling and them. Dee Dee's lawyer and them, they basically didn't have any extra witnesses. So it seems like any extra witnesses that are going to be brought to the table is coming from Durk's side. Now, that basically was followed by an interesting exchange where Brian Steele got himself involved. And I'm honestly absolutely cooking in the sun right now. I can't even see properly. My eyes are just burning. I don't know why, but I feel like this courthouse is way more difficult to report at than at the David courthouse. So I'm gonna put on my little sunshades right now, protect my eyes. I'm literally going blind out here. I feel like I'm in distress today. Today's just, it's a lot out here just in the sun on the pavement in downtown. It's mental. Anyway, so they went back and forth about like these potential witnesses and the government witnesses. They basically said that, what's your suggestion for the timing? They said that government witnesses could be kind of brought up just right before, basically the day before trial, and to reveal what kind of things. So it seems like that everyone needs to know at least like a day before trial, like who's going to be brought up, what kind of things are going to be asked. And the prosecution said, we gave exhibits and we agree, we want all the witnesses to be named ASAP. The judge says, well, look, this is more than you asked for initially. You basically need to ask, you asked to know the witnesses' names and their information a day before the trial. Now you're asking for it as soon as possible, and the defense basically just like agreed. So then Brian Steele got up and he basically said a couple really interesting things. He said that the government said that they would give us the witness order. They said, we don't want to give over our witness order before the witnesses testify. We don't want to give our exhibits for them the day before testimony. They basically said that we want to catch you. Brian Steele basically stood up and said, we want to catch you by surprise. We want to keep everything that we've got right up our sleeve right until we have to. And they said, we might not even use outside statements to counter what the government says. We might just use, specific things from the government's own exhibits to kind of hit them back with the things that they had said. And they said, look, we'll give exhibits, but we don't want to discuss the topics that we're going to be going over in the exhibits. So like, let's say, we're going to be looking at this giant amount of phone records. He said, we don't even want to discuss which topics that we're going to be going over until we're in the actual breaks. So I guess that means like lunch breaks or like breaks when the jury go out of the room. And they said that the government will be told not to share exhibits until witness testimony takes place. And the judge said, look, I understand, but that's not practical. They said these are going to be punishing trial days. We need to get through as many witnesses as we possibly can, as quickly as possible. A lot of people are interested in the case, and they said that I don't want people that are interested in this case or reporting on this case to act inappropriately and put information out there that they shouldn't be putting out there. And they said, look, the defense has to let the government know the day before. We're not going to have this like you're letting them know what you're going to talk about in between breaks in the trial. They said that's not going to fly. Like we actually you need to give them at least a day's notice. And the judge said, look, I don't want tons of breaks or sidebars. I don't want to send the jury in and out of the room over and over again, wasting their time. Doing disclosure and breaks is not going to cut it. He said, I will order a disclosure of all the evidence that you're going to be using the day before trial, ordering the government not to raise planned exhibits and questions with witnesses. And basically, from there, Dee Dee's lawyer basically said that we want you to provide certain exhibits 48 hours before they're going to be used. And then Brian Steele said we want it well before 48 hours. The prosecutor said 48 hours seem fair. Saying what potential witnesses will be and what kind of things might come up, 48 hours will give you that time. The judge says, well, look, you have to do it far enough in advance so that the defendant can respond if they're not happy with what's going to be presented. It can't be a last minute thing. And the prosecution agreed. They said, sure, our initial disclosure will probably have more witnesses than we actually need. And then this was really a shocker. The judge was like, how many witnesses? Prosecution said, oh, we probably got a total of like 35 witnesses. And the judge was flabbergasted. He said, 35? And then the prosecutor was like, oh, we probably got like 20 substantive witnesses, but like 35 total. And the judge literally said, I'm in shock at 35. He said, like, I don't know how we're going to run 35. And he said, like, how is that possible? Since the original plan, we lost a co-defendant, which obviously we know, some of the people that were co-defendants initially are working for the government now. But he was just absolutely flabbergasted at 35 witnesses. The judge trying to breeze through this case quick. And so at that point, he was kind of like, okay, this is sounded like it could be long. And basically asked, like, how long do you think this is going to take? And the prosecution said, even with 35 witnesses, we still think this could all be wrapped up in 1 to 2 weeks. And the judge was like, okay, I don't know if I'm believing that. Like, you need to start talking in terms of hours, not days and weeks. And he basically was like, look, this is sounding like 3 weeks, Monday to Friday, 8:30 to 4:30. Can we do this? Is this realistic? Now the prosecution were like, I don't know, we're projecting a lot of cross-examination, and this was very interesting. This was some damning evidence that came up, but the prosecution basically said, look, some of the testimony that we're going to put across, it could be a witness, but it could be really small. For example, and this is the first we've heard about it, they said they've got airport surveillance from San Diego airport where the alleged hitman landed and then drove to Los Angeles to go and do the murder. So this is the first we're hearing that like somebody might pop up onto the stand for just 3 minutes and say this is surveillance footage from San Diego airport where all the hitmen landed. That's the first time we heard that. They got that surveillance. I'm not gonna lie, some of the co-defendants looked a bit stressed out when they heard that news. So the judge said, look, come back to me on timings, we've got to work it out. But I know, look, this is the meat and potatoes of what we wanted to get to with this video. The most important part, we got to motion 5, and that's when the judge ruled on the song Pissed Me Off actually being used. The judge basically said, personally, he had watched the video, and he said, what does the government have to say about this? He said, I've sat there, I've watched the video, what's the government got to say? Let me know the argument, reiterate the argument that you want to use Pissed Me Off. And the government, this was probably one of their finest moments. The government absolutely cooked Durk on this one. They said, look, the song Pissed Me Off in the music video, it's got admissions to his motive. The imagery and the lyrics of the song basically give the perfect motive to the murder. Even though it was before Lil Pab was killed, it basically has Lil Durk admitting his desire to kill Quando Rondo. They said the song is an anthem for revenge for King Von. It was released on October 2021, around the time that people were calling on Durk to slide for Von. Durk in the song acknowledged that people were asking him to slide for Von. The word slide for Von came up in court a lot, and they didn't give any context. They assumed everybody in that courtroom, including the judge, knew about slide for Von. Even the judge said slide for Von. It was crazy, okay? They basically said that Durk acknowledged that people had been asking him for slide for Von. He said, the whole song is about being pissed off that everybody's telling him to slide for Von, so he's going to go and do it. He said he's asking people on the song, he's calling other people, let's go slide for you, we need to slide for Von. They read several of the lyrics. They said, since bro died, I can't be happy till they creep up on the score. They talked about why you posting Sun, why you posting True, and they said that True is Von's daughter. Now, everybody's been hysterical about, in the previous filing they said that was Von's son, not the daughter, and they got it right in court, so it really didn't matter, right? They said daughter. They said we're going to have this was one of the most damning things. They said we were going to have an expert witness who was there during the music video for Piss Me Off, and when Durk says, if you ain't got money, the camera overheated just as I was getting to the most juicy part. So they basically said that, look, they have an expert witness, he was there during the Piss Me Off music video shoot, and they brought up those lyrics when he said, put up money for, if you ain't gonna slide for Von, basically put up money for a hot car, put up money for a bond, and if you're really with it, hop in that coupe, all right? They basically said that hop in that coupe means go and kill for Von, go slide for Von. Money for a hot car, money for a bond, and basically they're saying that this witness that is cooperating is going to basically be testifying that they actually went and got the stolen car that was used in the murder in Los Angeles. Now, Durk on a song before the murder talking about put up money for a hot car, put up money for a bond, and they got the guy that went and got the hot car that was used in the murder is very, very damning. They said that a slider was used, a stolen car that is used for the purposes of committing crime. It was used in the LA murder, and specifically that, you know, their confidential witness that there is actually going to give testimony in court made it very clear that they had got the hot car. They had literally all the things that Durk said in that song they were going to do, they went and then did for Durk. So that was really bad. Now the defense had a little opportunity to clap back, and honestly it didn't go well. So the defense tried to clap back and get Piss Me Off taken out, and it didn't go well at all. The defense said, there's so many omissions related to this song, the court ruled music videos couldn't be used except with 2 exceptions, if it mentioned the bounty or the correlation between Didi and Durk. And the judge wasn't feeling that. The judge actually interrupted Durk's defense and said, look, my prior order doesn't bar the inclusion of Piss Me Off. It's to prove the motivation of murder for King Von. He said the inclusion of this song is to prove the motivation for murder, and he agreed that he feels like this song could potentially give, you know what I'm saying, cause to believe that it was revenge for Von. The judge admitted, look, the song is in memoriam for D Thing as well as King Von. So what's the actual basis of you not wanting it included? And as I've said before, this argument is low-key self-incriminating, because I said it in a previous video. I said you can't run around saying, oh, Piss Me Off can't be used as a slide for Von. It was a song about committing murder for D-Thing. You're still admitting that the song is a call to action for murder. And this is the argument that they tried to make, and it really fell flat. They said, oh, well, the Vic account related to the Chicago murder was severed. These visuals in this music video are mostly related to D-Thang. It's prejudicial. Durk's shirt says, long live D-Thang. These basically are just layers and layers of stuff that shouldn't. So the camera just overheated again. My microphones aren't working. This is a disaster. But anyway, I need to finish this, all right? So I'll definitely do better next time. My apologies for this being such a shoddy video. Was definitely unprepared today, so completely my bad. But basically, what the prosecution put forward, the defense were really having a hard time arguing against. So after that, they basically said, look, the people in the video aren't in this case. We've had the Vicar charges severed. All the visuals are related to D-Thang. They basically said exactly what I'd said in a previous video, which was the pretty flimsy defense of, no, this is a song about a different murder. This is a song about a separate murder that Durk might have been involved in. It was really a bad look. And they basically said the government just looked at the song on face value, but they don't have an expert. They don't really know what the song's about. They even had the gall to say they don't know when the video dropped or who it was made by or who wrote it. Like as if someone else could have made this song, someone else could have written this song and it wasn't Durk. They basically said, let me get a bit closer because you might can't hear me. They basically said that like all these things mean that with no expert, all of this is just prejudicial. They even said, oh, you know, when Durk says, oh, since bro died, they said, oh, you know, bro means brother. He's talking about D-Thang. It can't possibly be referring to King Von. And even the judge was like, bro could mean other things. Like, let's not be silly here. And then the prosecution basically said, look, we have a cooperator who sourced the hot car for the LA murder. They were there for the video shoot. And Durk's jewelry, the V. Roy pendant, it's a King Von tribute. And the judge basically said, look, motion granted, Piss Me Off is going to be allowed. That is it. And then after that was motion 6, and the judge basically just like went on to say, look, I agree with some of the defense's arguments. It would be a shame, since the crime is so serious, if the jury feel like they're just deliberating on the validity of rap lyrics. And the judge basically said, look, I believe many of the 10 songs that were put forward should be excluded, but I'm going to let 4 be tied to the case, 4 new ones. Redman had already seemingly been included, and it was funny to hear the judge say this, but the judge said, all right, I'm going to let 4 songs be included. Scoom His Ass, Back Again, Still Running, and Threats for Everybody. I'm going to allow those songs to be included and not the other ones. And the judge said, this was the craziest thing, and this was the biggest W that Durk took in the whole situation. I've said it before that one of the most incriminating songs in this whole situation is War About It. It's the one where Durk is talking about, no, he said, no, I said, let's go to war about it. Where he go, I bet you know the more, got him obviously making fun of Quando Rondo at the scene, screaming no after the murder happened. Now, the judge said, look, I thought about War About It. I feel like the reference to the word no, you know, is being attempted to be tied to the social media clip of Quando screaming no. But the judge said, I'm not going to allow this song. He said, no, it's such a common phrase. It's a reach to include it and suggest that Durk and a song talking about no is in relation to Quando Rondo at the scene. And they said that the state can give more evidence if they want, but we're not going to allow, right as it stands now, I'm not going to allow War About It to be included, which I personally thought was crazy because I think that is one of the most incriminating lyrics in the whole thing. And basically, at this point, the prosecution said, all right, well, certain lyrics were already admitted. The judge said, yes, if any lyrics that have been admitted so far, so like Redman, the music video, those are in, those are good. After that, the prosecution said, look, the defense pointed out deficiencies and certifications of business records. We're getting these recertified. But anyway, after that, they then moved on to this last bit, which was all about the motion to suppress Durk's phone evidence. Now, I think I'm going to go home and I'm going to record this at my desk because I'm literally sitting on the floor. My camera's overheating, which sucks. So I hope that was a good update. I'll get this one to you guys as soon as possible. I'll get the next one to you guys from my studio with the same notes. All right, it's exactly the same stuff that I heard in court. But yeah, so I would say it wasn't the best news for Durk, and then I'll be real with you, little teaser, spoiler alert, but the next video that I'm going to do about the phone data wasn't a win for Durk either. It was an L. He is looking, the judge is sounding like he's going to allow those phone records to be used. The judge didn't really care that 5 years was in between the phone being seized and the feds getting a federal warrant for the phone's information. So it wasn't great. So I'm going to wrap it up there. All right, I'm going to get out of these downtown LA streets. I need to go and take a shower after this one. But I'll be back with another update for you guys. Thank you for watching this one, and I'll see you guys next time. Appreciate it. I'm out.